Yes, good afternoon.
Good afternoon.
My name is Anthony Brima, Commissioner.
Thank you very much.
Good afternoon, Wakili.
Good afternoon.
Fatuma Sichale, Commissioner, karibu sana.
Thank you very much, Commissioner Judge.
Good afternoon.
Good afternoon.
You're welcome. My name is Olwande Evelyn, Commissioner.
Thank you very much, Mheshimiwa.
Good afternoon.
Good afternoon.
Dorcas Udwor, Senior Counsel, Attorney General and Commissioner.
Thank you very much, Attorney General.
Yes, thank you for that introduction. Council, we can start by you telling us your county and your ethnicity.
My county is Elgeyo Marakwet and my ethnicity is Keyo.
Very well. So I will start you off. If you were to present to us a picture or a poster or a painting of an ideal judge of the Court of Appeal, who is an ideal judge of the Court of Appeal, then you tell us how you fit in that bill. What specialization or skills or talent or knowledge or value that you are going to bring to the Court of Appeal. If you can do that in 5 minutes.
Thank you, Chief Justice. I will probably describe myself, and then at the end of it, I will say that I fit into the bill you have just described. This is about the 30th year of my practice as an advocate. In the course of the 30 years, I have practiced practically at every level of the courts in Kenya, tribunals. I have also practiced internationally. I have practiced at East African Court of Justice. I have appeared before Sports Court in UK. I have appeared before the ICC. In terms of what I would bring into the judiciary, what probably distinguishes me, because that's my understanding of the question you've asked, I would say I would bring the cumulative learning I've learned in those about 30 years, both nationally and internationally. I will probably just make reference to a number of what I consider to be frontiers in the practice I've had. I will start with probably the international experiences I've had. I have practiced the sports court in UK, and the outstanding case, with your permission, I will not mention names, but I will just describe the issue that obtained in that case. Being that I had a client, I'm just picking one case, the client who was accused of taking performance-enhancing substances for purposes of enhancing his performance in athletics. And around that case, I lost the case, but still the issues that obtained are significant. The first issue was we were contending that the handling of the samples used to incriminate him were not properly handled, including there were about 3 people who handled it. They were not maintained in fridges the way they were supposed to. The courier means that were used to send them to Geneva was not properly done. And so our first contention is that in every probability the samples had been tampered with. The second argument we had was that the substance he was accused of having ingested is a substance that naturally obtains in the body. And the more practice you do and the higher the latitude of your practice, the more the body will generate the substance. And the case was lost by reason of this dichotomy, that there is a way it can be determined whether the performance enhancing substance is natural or artificial, whether it has been ingested. And because of the limited scientific infrastructure we have in Kenya, we were not able to achieve the type of level they had to contest the scientific report. And so the court disallowed our case on the premises that the report that they had produced using the superior labs that they had not been contested. The second case, which I consider very significant, was a case I handled in the East African Court of Justice in the year 2006. And the issue was that Article 30 and Article 50 of the East African Treaty required that the representatives to the East African Parliament must be elected. What then had happened in Kenya is that the government then had, using acclamation sort of in Parliament, picked the people who are to represent Kenya in the East African Court of Justice. And we filed a challenge saying the acclamation does not fit the definition and the intention of the Article 50 of the East African Treaty. And our argument was that the representation in the East African Parliament should be based on the ratio of the representatives of each political party. After arguing making the presentation, the first thing is we got an injunction to restrain the Parliament from convening and from recognizing the Kenyan appointees, the ones who had been chosen by acclamation. And then after substantive hearing, the East African Court, we persuaded the East African Court that indeed what was done in the Kenyan Parliament did not amount to election, and so the Kenyan Parliament was constrained to conduct proper elections, which gave a proration of the representatives. I take pride, probably improperly, in the fact of having been able to stay the recognition of the Kenyan representatives, staying the conduct of the affairs of the assembly until that issue was resolved, and it took about a year. The last international case I wish to make reference to was the case of the ICC, and the issues were whether the clients I was representing were culpable for crimes against humanity, displacement of population, torture, and other conducts that fall under the inhuman treatment. And the significance of that, probably, Chief Justice and Commissioners, is this: that the court is an hybrid of common law and civil law. CJ, I know you gave me 5 minutes. I'd have really liked to make, to bring out the significance of the fact. Yeah. Yes. So probably the point I wanted to make then, CJ, on that point is that the pressure that was on my shoulders, the pressure that was on the team I was leading in that court, was the speed with which we were required, or I was required, to appreciate what the civil law brings into the proceedings. And I recall that at the start of those proceedings, every second minute, I was raising objections because I'm used to common law system where you can't bring evidence that was not properly acquired, you can't bring newspapers as evidence, you can't have a judge calling for evidence or calling for witnesses. And eventually I learned that under civil law that is possible, and being an hybrid court that had to be allowed. Now the point I'm making is the speed with which I needed to learn, and considering how the general progression is, we are in a global village, and the fact that most of our jurisprudence now make reference to international legislations, I would want to contend that I would also bring that experience and that variety into the Court of Appeal if you find me deserving of getting into that office. In the Kenyan situation, I have practically, as I already said, I have practically practiced at every level. I have practiced, yes. An ideal judge would be a judge who fits into the bill of the requirements of Article 10, Article 232, and Chapter 6, together with the Bangalore rules. A judge who is measured, who has a good temperament, who is competent, who is diligent, who is disciplined, and who is competent. Yes, and one who is ethical. Yes. Thank you, Chief Justice.
Thank you, Honorable Chief Justice. Mr. Katwa, a few questions from me.
Yes.
It's been long since I last saw you making your maiden appearance in the then Court of Appeal in Nakuru.
Yes.
And it's like, it's been many years and you really traveled the world, as it were. Now, you are endeavoring to join the Court of Appeal, and I can tell you that it is not so rosy on this side. And I would like us to focus on Article 168 of the Constitution. Article 168(1) that makes provision as regards the removal of a judge. I'm more interested in the last two. That is, a judge can be removed on account of incompetence and for gross misconduct. So there are competing interests. A judge says, I'm independent, do not look at my decision. The Constitution says you can remove a judge for being incompetent. The question that I would want to ask you is, in what way or ways can the Judicial Service Commission determine whether a judge is competent or incompetent?
Thank you, my lady. First of all, I'm surprised that I'm being asked that question, because I know it is a very topical question currently, being the question of the possible extent to which judges or judicial officers could hide behind judicial independence to either hide misconduct or incompetence. And in direct answer to your question, I would almost say you would probably look at the three criteria that were used, that were ordinarily used in matters of judicial review, whether it is so manifestly on its face irrational to a point where you take the view that a reasonable tribunal, a reasonable person properly trained in law could not come to that conclusion. Parameters that occur to my mind would be, for instance, if a judge were, for instance, a high court judge and decides to take upon himself or herself a matter that is an ELC matter, then clearly, to me, that is a combination of both possibility of misconduct and incompetence, and that would be an issue. If a judge were to take, say, 5 years to make a decision, that would go into both misconduct and incompetence. And so I would say it is just how grossly out of place and improper the decision is that then would attract the jurisdiction of Judicial Service Commission to challenge the propriety of the conduct of the judge. Commissioner, I hope I have answered your question.
You have, to some extent.
Yes.
So you talk about a judge taking a file that should be really with the, not in his court or our court.
Yes.
And then you also give the other example of
Inordinate delay.
inordinate delay.
Yes.
But again,
Yes.
you did indicate that incompetence or gross misconduct could be housed in the judgment.
Yes.
And here is a situation where a judge is saying, I'm independent,
Yes.
do not look at my judgment. So they are not those ones that you are able to see that a file moved from one registry to another, or that this matter was delayed for 5 years. But it's not amongst those. But basically it's like saying that there is gross incompetence in the judgment or in the ruling. What does the Judicial Service Commission do in an instance like that?
I would maintain the general proposition I made earlier on, being that if the decision looks so grossly out of the way, that you would then wonder whether the person is trained as a lawyer at all, that a reasonable judge would not come to such a conclusion truly trained in law.
So how do we get to the conclusion
Yes.
that the findings therein are really gross?
I would say case by case.
And we look at the judgment?
Yes, that's my point, that it would need to be, the judgment would need to be looked at. Probably corroborating material would also be comparable decisions, whether other decisions made by the same judicial officer
But supposing a judge, sorry to cut you short,
Sure.
supposing a judge says, do not look at my judgment. If anybody is aggrieved by my decision, there is the right of appeal. But I'm independent and I can say what I want to say. Anybody who has a grievance should take up the matter on appeal.
I would say it is not right to say, okay, of course I would say the parties involved are entitled to appeal. The existence and any exercise of jurisdiction by Judicial Service Commission should not take away the rights of parties to appeal or to go for review. But simultaneous with that, I seem to understand your question to be whether the Judicial Service Commission can look, analyze, and make a decision on a judge's judgment. And my answer is that yes, the Judicial Service Commission, if it is pointed out by parties that this is so grossly wrong, this is so improper, it is an indicator of either incompetence or improper conduct, then the Judicial Service Commission should be able to look at it, analyze it, and take a view of it. That's my position, that the Judicial Service Commission can look and challenge a decision without prejudice and without affecting the rights of appeal or review.
Thank you for those thoughts, and I agree indeed that the issue is quite topical.
Yes.
Yeah. Now, let's move to another area. In a suit, there is an entity known as an interested party. Yes?
Yes.
So you have your plaintiff, you have your defendant, and then there is an interested party. What are the limitations, if at all, of an interested party in a suit?
So let's first start by saying an interested party is ordinarily brought in by a defendant with the intention of seeking that the issues between himself as a defendant and the third party be determined in the same hearing.
Is that an interested party? Or is that a third party?
Oh, sorry. Yeah, that's a third party. Sorry.
Yes.
Sorry.
We are talking about an interested party.
Yes, I see that. Sorry. And your question again, Commissioner?
What are the limitations, if at all, of an interested party in a suit? The suit where we have a plaintiff and we have a defendant.
Yes.
Now here is an interested party.
Yes.
What are the limitations, if at all, of this interested party in that suit?
Okay, so my reading is that an interested party would seek to be enjoined and must demonstrate a stake in the dispute and must take a position of what you would prefer that the court determines in the entirety of the suit. In terms of limitations, I would say that their limitations would be limited to the extent of the interest he has indicated he has in the case. It's not open for him to seek to participate in issues that have nothing to do
So
with
he cannot frame issues? He cannot frame issues?
He can participate in the framing of the issues, but he can only participate to the extent of the aspect attached on him or her.
Does he file a defense?
The extent to which I would go is that he would file his pleadings indicating what his claim is and what he's seeking.
So he would not file a defense?
Yes.
And basically, what is his role? Because we have these two contenders in the suit. What is the role of this interested party vis-a-vis the role of the plaintiff and the defendant?
I think in the Mutemu case, the court said that interested party is limited to articulating the aspects that touch on him and cannot, for instance, seek to file an appeal or to introduce a contention in the suit because the suit belongs to the main contesting parties. So he's a third arm, is on the wings.
He's subservient.
Yes. But not as subservient as an amicus. Amicus is way out, and amicus is supposed to be neutral,
all right.
Only bringing expertise.
And finally, from me, can he apply to join in the suit after the proceedings are finalized?
Not when they have been finalized. He would need to enter before determination is made.
All right.
And
Thank you.
Yes, thank you.
Thank you.
Yes, good afternoon again, Mr. Kigen. You have
Good.
said that you practiced in the East African Court of Justice?
Yes, and I sued your predecessor.
Thank you. A quick one, yeah? What is your understanding, general understanding, of the jurisdiction of the East African Court of Justice under the East African Community Treaty?
I know there has been an amendment recently to reduce the jurisdiction of the court after a number of cases which I think politicians were not comfortable with, to reduce the jurisdiction. But before that, the jurisdiction was such that any dispute that touches on international relations could go to them. So you wouldn't go, for instance, on an issue, say, of a criminal offense that happened in Kenya or an accident, but if it is an issue that requires resolution touching on more than one country in the East African jurisdiction, then you could go to them for resolution. That is my understanding of the jurisdiction before the amendment. May I also confess that I haven't kept track with the amendments, the latest amendments, but that was the jurisdiction I was aware of when I went there.
Now, two questions.
Yes.
The court has entertained cases where it has attempted to review or indirectly supervise decisions of national courts on matters traditionally within the domestic jurisdiction of those courts. What is your view?
My view is that it shouldn't. My view is that the municipal issues should be left for the municipal jurisdictions to determine, because the East African Court of Justice that is meant to facilitate the comity of the countries. It is not meant to supervise the countries. So my view is that they shouldn't go that far.
And a second question to that.
Yes.
The court has developed an implied mandate through interpretation of the Rule of Law Treaty 6 and 7, wherein the court has entertained cases of human rights. Interestingly, Article 27 of the East African Treaty has left room and allowed for future expansion of the jurisdiction of the court to entertain human rights matters, which has not yet happened. My question is, does the East African Court of Justice have mandate over human rights matters?
I would maintain the general frame of the answer I've given earlier, that if it is a human rights issue that cuts across borders, then it has jurisdiction. But if it is a municipal issue, I would contend that they shouldn't seem to walk into Kenya or Uganda to determine human rights issues in municipal jurisdictions. I would maintain that. That would be my argument. But if it is cross-border, I would see the need for that jurisdiction to be exercised for purposes of interpreting the various and competing positions in the various jurisdictions.
What would be the relationship between a trans-border human rights issue and interpretation of the EAC treaty?
No, I would agree that if it is a question of just interpreting the treaty, yes, I would agree that they have jurisdiction to interpret the treaty. But if it is to enforce human rights or to interpret the violation of human rights, that is the point at which I would contend that if they are to interpret, it has to be a question that obtains in the country, not to interpret, for instance, the Bill of Rights for Kenya when the cause of action arose within Kenya and between Kenyans.
My second question is on contempt of court. Article 24 of the Constitution requires that any limitation of a right or fundamental freedom be by law. So no right can be limited except by law. In Kenya presently, we have no substantive Contempt of Court Act prescribing penalties. If an appeal came before you challenging a fine or a custodial sentence imposed for contempt of court, what is the constitutional and legal source of the court's power to impose the sentence, and how would you assess its validity under Article 24?
Okay, so let's first, with your permission, Honorable Attorney General, I would first of all say that the perimeter is used to determine the propriety of limitation of rights under Article 24 is that it should be reasonable, it should be based on a written law, it should be lawful, and should be to the extent necessary in a democratic society. Now, the jurisdiction to punish for contempt is a question of the dignity of the rule of law, combination of the dignity of the rule of law and the dignity of judiciary. Not necessarily an individual judicial officer, but the functioning of judiciary. And so the need to punish for contempt is informed by that need that the court should be respected. And so I would say that in determining whether there is propriety in the punishment meted out to an individual, the question is whether the facts support the need for the court to assert its authority and the need to assert the authority of the rule of law. Yeah, that would be my answer, Attorney General.
Would you agree with me that Kenya's approach to contempt of court proceedings requires reorientation, particularly in cases involving collective or institutional action by the state? And I'm saying so because in some instances, the contemnor before the court is not directly responsible for, or even is not in control over institutional compliance, or is not responsible for the action being complained about. Do you think we need to reorient, review, and or re-legislate issues to do with contempt of court?
My answer is this, that yes, there is need to relook at it, and probably we should just go back and say that there was already an enacted contempt of court legislation, which was thrown away because of the propriety with which it was enacted, and more particularly on account of lack of public participation. I think it would be good to bring it back. That's one. The second one is, it is my view that the judges, or sorry, I shouldn't say judges, judicial officers are given too much discretion on that issue of contempt. Over the years, I have seen judges punish people, for instance, when the phone rings inside court, sometimes when people converse in court. And in a way, I think that is too much latitude, and there is some abuse of that, because I wouldn't see the propriety of punishing sometimes very old people who do not know how to turn off the tones of their phones in court. So there is need, and even ahead of legislation, probably a policy guideline on what is the context under which punishment should be meted. I know of an instance, and I will not mention names, where a phone rang and a judicial officer adjourned the court session at 11 and did not come back in the name of being upset. And when he asked whose phone it was, nobody was willing to come forward. And so I want to say that there is need to reorient with a view to managing the judicial officer's latitude in it, because sometimes it has been abused. Now, you tie it up with the question of state officers. I would want to say this, that my understanding is that if a state officer is brought in accused of contempt, and if his argument is, as you stated, that I'm not the one responsible. I know the latest trend has been that public officers have been brought in for a long time. State officers were not making payment of decrees, especially monetary decrees. But in the recent past, I know courts have moved forward to issue notice to show cause and to compel explanation as to why payment has not been made. Which is a good development as far as I'm concerned. Now, if the argument is, as you say, that the state officer is not the one responsible, I would imagine that a properly trained and responsible judicial officer would not take it upon a state officer if he were to be able to demonstrate that he's not the one responsible. And so the answer lies in the answer to your question lies in the question itself, being that the explanation that I'm not responsible should be adequate enough to allow the officer to escape, and if there's an unreasonable determination made against that officer, then there is options for review and appeal.
Thank you.
Thank you very much.
Thank you, Chief Justice. Council, there's been a lot of debate, particularly on in terms of distribution of estates, and it's an issue that, if you're listening to the interview, never ends. It keeps on coming back, goes round and round in circles. Now, I wanted you to explain to us how property is shared in a polygamous estate, number one. And number two, what are the widow's beneficial rights in a polygamous union? And number three is whether you are aware of arguments and controversies on the exercise of discretion in distribution to widows or other beneficiaries.
Thank you, Commissioner. The shares, the distribution in polygamous environments is that you count the units being a combination of the totality of the children and the totality of the widows, and then you share equally. And equally is qualified by the decision of the Court of Appeal. I know there have been subsequent decisions, but the leading decision is still Rono versus Rono, being that equality is not necessarily a mathematical figure, but it could be with an element of equity, an element of discretion by a judicial officer. So my answer is that it should be totality of the units, combining the children and the widow. Probably just to mention that there is a controversy there on the issue of children born out of wedlock, but I think that has been resolved, that they are equally entitled to inheritance. I think the margin that probably has not quite been determined is whether their share is exactly the same as the share that the principal parties get. And I want to allow for the room of the possibility that there are new decisions that have determined that, but I know that's a frontier that has not been determined to the best of my knowledge. Now, the beneficial rights of widows is to the effect that they have a lifetime interest. That is, they have an interest in the property to the extent of their lifetime, and upon its expiry, then the property defaults to the children. The controversies, I think there are so many controversies on this.
You can.
Yes,
Three?
Yes,
Three or
thank
four,
you. I could do more than three. I think the first controversy is a controversy that was flagged out by my Lord Justice Murima in another forum, being what happens, and I had somewhat expected this question also from my Lady Chief Justice, because she's the one who flagged it out in 1996, being to what extent should a widow who worked with the husband and accumulated all the wealth share the property equally with the last born child of the subsequent widows and who has not worked at all on the property. And the controversy then is this. The first element of that controversy is whether Section 3 of the Succession Act, which says that you distribute free property, should be understood to mean it should be free of the trust value that the widow is entitled to. More particularly, whether you should exclude what the widow who worked on it is entitled to before then you deem the residue as free property. So that is the first controversy. And the second element of that, before I just discuss that controversy, is the question of the extent to which you can consider matrimonial properties law in a succession cause. Now, the discussions on this, because it's an issue I've applied my mind quite a bit on, is this, that Justice Koome, as she then was in 1996, lamented that Section 40 should be amended by the law reform so that there is recognition of a widow who has worked on the property. I should not be treated like somebody who came after all the property has been acquired and get equal property. Then I think Justice Rawal around 2003 supported the same point, but unlike Justice Koome, she was daring enough to say, I must exclude what the first widow is entitled to. And then from the year 2016, 2017, 2018, there was very animated discussion around that subject. And the decision that eventually went to the Court of Appeal was decided by Justice Kimondo to the effect that I must exclude what, that probably Justice Kimondo and Justice Mumbi Ngugi were the ones who were very categorical. They went way ahead and said as far as we are concerned, we must recognize the property that belongs to women, and we must exclude it, and the residue then becomes free property for distribution to the rest of the estate. Justice Kimondo's case then went to the Court of Appeal, and I think the Court of Appeal then determined that indeed Justice Kimondo was right, that the property belonging to the eldest widow should be excluded before it is deemed that the residue is free property.
Okay.
But it's not yet complete. The controversy has become very acute. Then, in the recent past, Justice Nyakundi, Justice Mushoka, and Justice Wananda have taken a different view in decisions made in 2024, and I'm saying this with a timeline in mind, being that the Court of Appeal made that decision in the year 2019. But in 2024, as recent as 2024, Justice Nyakundi and Justice Mushoka still maintain that indeed, if you say that matrimonial property should be discussed in a succession course, then it amounts to the question that the Honorable Attorney General has severally asked, that it amounts to activism. It is amounting to a judge craft. It amounts to the judge amending the law to introduce what the legislators never intended, being that they never intended that a succession case should now look back to matrimonial property. And then he makes a distinction that the Matrimonial Properties Act says that upon dissolution of marriage, upon the marriage being dissolved, then matrimonial property process can commence. And according to him, death does not dissolve marriage, it ends and terminates it. And then he compares himself with what Justice Kimondo says, because Justice Kimondo says that the death dissolves marriage. But Mushoka says, no, what death does is that it ends and terminates. And so the argument still goes on. It brings back the question of stare decisis. To what extent can a judge say, I am so strongly minded on this issue, to the extent that even a binding Court of Appeal decision does not tie my hand? And I think the language used by Justice Mushoka and Justice Nyakundi is indicative. Justice Wananda seems to agree with that, but then says, but me, unlike the other two, Justice Wananda's decision is 2025. He says, me, unlike Justice Nyakundi and Justice Mushoka, will be bound by stare decisis. So I'll follow what the Court of Appeal says, though I disagree. But the others say we are daring. Should I go on?
No, okay. I think that's enough. I think you must be passionate about this, but
it is.
There is something you raised about. You spoke about the children that are born out of wedlock.
Yes.
I don't know whether you've read the recent decision by the Supreme Court about a Muslim.
Yes, I have read.
Would you say
yes,
that decision has resolved that issue?
Not necessarily. So my understanding of the Supreme Court decision was the argument by the family of the deceased was that under Muslim law, any child born out of wedlock cannot inherit. Then the Supreme Court says we are bound by the Constitution that where we encounter a custom that borders on being inconsistent with the Constitution, we must be faithful to the Constitution. And in consequence, therefore, the Court of Appeal said that a child is a child, and for as long as it is not contested that this is the child of the deceased, he is entitled to inheritance. So the difference between your question and what the Court of Appeal said is that the Court of Appeal merely said that he is entitled to inheritance. And the question that I was saying, I am not sure if it has been resolved, is whether then when they go back to do the distribution, because the Supreme Court said go back and have the distribution done, is whether he will get equal with everybody else, or he will be treated differently by reason of not having been in a formal marriage environment, not being born in a formal marriage situation.
Okay.
Yeah.
Thank you, CJ. That's all.
Thank you so much, Honorable CJ. And Council to questions. One, still within the family parameters, the issue of spousal consent. The law at the moment relating to some land transactions provides for spousal consent, where properties are registered in the name of one of the spouses. Now, do you think that is a necessary provision? And two, do you think there could be any exceptions to this requirement? Maybe you may demonstrate that by examples.
Yes, thank you. I'm not sure I got your question quite completely. Did you say some land transactions require spousal consent?
Yes.
And if you say it, then I would say my understanding is that that's not the position.
Yes.
The spousal consent is required unconditionally on any land transaction for as long as the property is matrimonial property. So the moment the property is matrimonial property, the spousal consent is invariably required.
Now, a minute.
Yes.
You know, I framed my question knowing the position in law.
Yes.
So I expect you to answer the way I had put it. But you are right, I had cornered it in such a way that I wanted you to pull out the issue of matrimonial property. Excellent.
Thank you.
Let's go to the other bit.
But I haven't answered your questions, though. the question was whether it's necessary.
Yes. But that was the catch.
So there were two elements to your question. The
Yes.
first one was whether it's necessary,
Yes.
and whether there are exceptions, and I think I've answered the second blimp being that there is no exemption if it is matrimonial property. Whether it is necessary, I think I take the view that it is necessary because we are coming from an environment where women and children are highly disadvantaged, sometimes by the conduct of the male segment of the society. And the introduction of that section was very important so that you protect the rights of women and children. And it's an issue I know Justice Mombi Ngugi has expressed herself very strongly in one of the decisions, that there is need to treat women the same as men, including protecting family property. I hope I have answered the question now.
Okay, thank you. And now we move from there to Parliament. And I want you to imagine that you are a member of Parliament. Have you ever vied before?
No, I haven't.
No, I want you to imagine that you are a member of Parliament. And in the National Assembly, there's a debate going on a bill which is intending to limit the freedom from cruelty. Now, what will be your contribution, either for or against that motion?
Okay, thank you for the question. So in your illustration, you said if I were an MP,
Yes.
I don't know whether you meant to say you are an MP and simultaneously you are a lawyer. If I were an MP and equally a lawyer, I would say Article 26 secures Article 25, I think, and please allow me if I'm wrong on the article, but it is not one of those articles that can be derogated, and so cruelty limitation on the aspect of cruelty is not allowed. But if your question was intended to implicate Article 24 on the limitations that are to be placed on the Bill of Rights, I would say that it can only be legitimate insofar as it is absolutely necessary, it is reasonable in a democratic environment, and it is based on written law, and it does not affect the other rights, the rights of others.
Okay, you'll check with Article 24 on the rights which cannot be limited. The freedom from cruelty cannot be limited.
Yes, my lord. I think I just said that, so please don't deny me, Max, because of that. I said that. And I said, I was saying Article 25, and I said I might be wrong, so it should be Article 24. Yes. It's some of the rights that cannot be taken away, the rights to fair trial, rights to habeas corpus, cruelty, servitude, slavery, and others.
So your position will be against that bill?
Yes, it can. It cannot be derogated.
Okay, thank you. Thank you so much, and I wish you the very best. Thank you, Honorable CJ.
Yes, Council, I want you to further develop a point that you spoke to when Commissioner Mwanza asked your question. Although your statement was in regard to succession, you are aware that under the Constitution, parental responsibility exists whether the parents are married or not. Does that change after death? Just following up from what your last statement was, that you are not sure now that it's gone back to the High Court whether or not the child will get equal share because the parents were not married. So I'm just trying to understand if logically the Constitution says that parental responsibility exists whether or not the parents are married. In the case that you're talking about, what would be your opinion, therefore, of what should happen in that case?
My opinion is that the child should get equal share to the extent to which he is a child of the two parents, and to the extent to which you cannot place any blame on the child, and should not be punished by limitation of his or her entitlement merely because of the condition under which he or she was born.
Okay, thank you. I know we have seen you in the Supreme Court fairly often, and I know that you must be familiar with a number of our decisions. In the finance bill matter, the Supreme Court issued guidelines on two issues. One, issued guidelines on the issue of public participation, and two, issued guidelines on declarations of unconstitutionality by courts. I'm wondering whether you can share with the commissioners here maybe one or two guidelines that the Supreme Court issued on public participation, and one or two guidelines that the Supreme Court asked the courts to consider before they make declarations of unconstitutionality.
On public participation, I would say two things come up. One is the need to formulate a legislation, or at the very least a policy that guides on an effective process of public participation. And the reason is that the question of whether a process that has been conducted is an effective public participation has remained a very subjective one. One judicial officer would deem a process to have properly amounted to public participation, another one would deem it not to have been. That's one. The second, I think it could be, I'm conflating authorities, but I know this has also been said, that the data of the public participation should be available, and a justification should obtain on why inputs from the public have resulted in a choice of one way or the other. How do you justify having chosen this vis-a-vis this that came up in the public participation? You said one, I've said two, so
that's enough.
Okay.
On declaration.
On declaration, the Supreme Court concern was public interest, that there should be concern for the public good in declaring a statute unconstitutional, and in consideration of the public interest and the ramification of the decision, the Supreme Court gave a stay of the invalidity or order of the statute. I think that is, I'm using the words carelessly. Well, I can't remember them accurately, but I know there was a statement to the effect of staying the decision of the invalidity of the statute pending a substantive consideration by the Supreme Court of the propriety of the bill because of the public interest and public ramification.
Thank you.
Thank you too.
Thank you, Chair. Good afternoon once again, Council.
Good afternoon, Commissioner.
And I do agree with you on your question whether matrimonial property is free property.
Thank
that
you.
we can discuss later.
Thank you.
You have submitted 5 written samples, and they touch on international or submissions on international crimes, community land, and criminal matters at the domestic court. Your writings demonstrate strong legal reasoning, meticulous flow from fact into law, and strategic use of precedent. Your temperament and tone are consistent, well balanced, professional, and particularly in the community land matter, you did critique the government's action in an objective manner. So, good job when it comes to your writing skills.
Thank you very much.
I have a quote here, and then I will ask you a question thereafter. Conflicting decisions transform courts from law clarifiers to law confusers, with profound consequences to fairness and the rule of law. Do I repeat, or are you okay?
The conflicting decisions?
Conflicting decisions transform courts from law clarifiers into law confusers, with profound consequences to fairness and the rule of law. At the Court of Appeal now, there are conflicting decisions. I'll just mention about the issue of filing of notice of appeal. I don't know whether you're aware of that. The Otieno Ragot matter and the multi-choice matter. So there is one decision that says filing of a notice of appeal merely signifies, my apologies, an intention to appeal, and the other one says that signifies an intention to appeal, and the other one says that the other one says that such notice confirms that, sorry, I'm trying to read. One says that filing of a notice of appeal merely signifies an intention to appeal, and the other one says that it confirms that the appeal has been filed, and the High Court's powers to review any matter is ousted. And then the other conflicting decision is on land control board. The consent parties must get before a transaction in control zones are considered valid. So what is your take on conflicting decisions of the court you intend to join, and what will you do to promote jurisprudence coherence?
That's a very difficult one, but I would say probably from time to time there might be need for consultations so that there is harmony in especially matters that are not very controversial. My view of it is that it is not wise to muscle the courts that they must make a decision along the lines of a previous decision because it had been previously decided that way. There should be room for development and for fresh mind. But at the same time, like this one of the notice of appeal, I think it should not deserve the controversy it attracts. And I think in direct answer to your question is probably the need for consultation, even at the totality of the level of that appeal level, because then the question would be whether one segment of the judicial officers made the decision not being aware of what the other segment said. You had asked the question whether I'm aware. I must say I'm not aware, and I haven't read, but the points you make are things that I think I am aware that could possibly arise in such a situation. And so I would say there is need for consultation, and there is need for easy access to precedents around the issue, so that even as you make a decision, you are aware of what has been said previously, without necessarily saying that everybody must say what has been said previously. There should be room for development of the law. I know Land Control Board issue has been very contentious, and I'm aware that some decisions have been made in the High Court that where there is very clear injustice in using Land Control Board consent to deny rights that have accrued to another party, the court could relax the absolute need for Land Control Board and recognize the rights of another party, that a party should not be punished for that specific issue. I am not sure I've answered your question quite precisely, but okay, thank you.
Yes, you have, but the other question still linked to that, is it enough for a court to just state that this is a decision from a coordinate court, I'm not bound by it? Is it just enough for a court to just issue such a statement when they don't agree with the decision of a court of equal status?
For me, first of all, a decision of coordinate jurisdiction being a decision of similar court is not binding, it is persuasive. And therefore, to the extent to which it is persuasive, for fairness and for certainty of the law, a judicial officer coming into the matter subsequent to a previous decision on the matter should be able to acknowledge the previous decision, the reasoning in it, and distinguish why it doesn't agree with it, so that there is logic and there is certainty, so that there is basis upon which to say the law could have moved from here to here, or otherwise to say a choice can be exercised on which of the two decisions is superior. My view is that there is need for acknowledgement, but it doesn't bind.
Okay, thank you. I'm okay with the responses. Thank you, Chair.
Thank you, too.
Thank you, Chair. Once again, good afternoon.
Good afternoon.
I'm not going to belabor your distinction, because you are a very well-known personality in the legal sphere. Your wealth of experience and your contribution to the growth of jurisprudence is well-known. I want to discuss something different in the area of performance. Now, in your view, is the carrot and stick approach the best approach in motivating performance? You can explain your answer.
I would say yes. Yes, without being manipulative at it, being that it should be structured so that it's not whimsical. It should be based on some structure, some procedure, some policy, so that there are instances when the reward is predictably based on some logic, and the stick is also based on some logic, so that it's not whimsical, it is not individual based, it is not capricious, it is based on a criteria.
Maybe if you could expound, maybe using examples so that we understand, when do you say it's capricious, when do you say it's based on logic?
I would say if it is possible, it should be such that the person to be rewarded with a carrot should be a person whose performance can be established with some scientific, in some scientific way, that everybody can look at it and satisfy himself or herself that indeed this person has performed and is deserving of the reward. And for the person who is to be disadvantaged, there should be a criteria of evaluating the performance, and there should be a relationship between the semblance of the punishment and the performance, so that it is not the hairstyle or the gender or the age that has rewarded you. It should be based on some scientific criteria. So I think it goes to the question of perimeters, whether there are perimeters for determining who is to be rewarded and perimeters for determining who is to be disadvantaged.
Okay, if I understand you correctly, you are speaking to the issue of criteria.
Yes.
How we go about identifying someone so that there is a good performer, so that there is a carrot.
Yes.
And a poor performer, so that there is a stick.
Yes.
But is it the best approach to base a performance appraisal framework on, so that the only concern is whether if you've performed, then you are rewarded; if you have not, then you are sanctioned?
Okay, so let's say the stick and the sanction is probably too drastic. The reward, I would, without qualifying, I would say is something I would support. I would support that somebody who has performed both quantitatively and qualitatively should be rewarded. The person who has not performed so well, in my view, should not necessarily be punished or ostracized or condemned, but should be motivated to also perform. So I would be restrained in the extreme use of the word stick and sanctioning. It would be more a question of trying to see if you can uplift them to a point of equally performing. I think there is a second limb of your question as to whether it is the best way. I would say you combine it with all other means, training, capacity building, resourcing, all that can facilitate equipping whoever it is, and getting to know also the conditions under which the non-performer is. Could it be a medical condition? Could it be an addiction? Could it be that you are requiring him to reach out to things which are placed very high when he's a very short person? So there is also need to understand the context that the person who is not performing could be not performing.
Okay, thank you for that. Now, looking at the judiciary performance evaluation framework, which I imagine you must have a fair idea of because you've been practicing for quite a while, would you say that the framework is a carrot and stick affair?
I would say I can see carrot in the acknowledgements and the accolades given to good performers. I would say I don't seem to see the stick. I don't seem to see necessarily a very explicit event of seeming to punish those who do not perform. And I think that's as much as I want to say on that. I want to be careful about it.
Okay, yes. Then maybe we can look at something else.
Yes.
In the last Soja report,
yes,
the Court of Appeal wasn't doing quite well,
yes,
in the area of clearance of backlog. Actually, they were the second lowest at 7%. It's obvious what speaks to that is the question of numbers. Now, if you are successful to join the Court of Appeal, because the numbers is what we are trying to cure, if you're successful and you join the Court of Appeal, given your vast experience both internationally and locally, what are some of the innovations that you would introduce in that court to improve case clearance as well as reduction of backlog?
Okay. The first one is, it is my view that the Court of Appeal as probably the leading backlog in terms of applications, and the backlog on the applications has the ripple effect of also delaying the conclusion of cases. So one of the thoughts I would have is that incentives should be put in place to encourage parties to focus more on dispensing with the main appeal rather than the applications. And correlated with that is my experience in the Court of Appeal several times, is that you spend as much time arguing the application as you spend in arguing the main appeal. And so if the time dedicated to the contestation on the applications could be invested more in the main appeal, it could really help. And the question then is, what holding arrangement could be put in place on the contestations on the applications so that parties can be attracted to go to the main application? Probably engaging them on some holding arrangement where courts do not need necessarily to write rulings, but parties agree on an interim arrangement that accommodates the hearing. I would see parties then saying that in consideration of having agreed to waive the need to argue the application, then you should accelerate the hearing of the main appeal. I would want to say that a device should be put in place that accommodates those two, that there is a sense of a reward of an accelerated determination of the appeal for those who can enter into arrangement. Number two is probably, I have seen it in the Court of Appeal in the recent past, but probably it needs to happen more proactively. That most of the applications, I would say probably over 80% of the applications are 5.2b. The issue of application under 5.2b is so notorious that you could almost doubt if there is anything new anybody could say on 5.2b. The implication of that then is that there is the question of whether it is therefore necessary for judges to say, come back for a ruling, whether it should not be possible to just do a ruling there and then. Number three is the possibility of also amending the rules, because I know it is contained in the rules, that the applications for 5.2b should be scaled down from the need for 3 judges to preside over it to a situation where probably 1 judge can hear it and probably accelerate then that process. With also the possibility that the judge who has been asked to certify can even give interim orders so that there is movement on that issue. The other issue which applies to both applications and the appeals is that, okay, I don't know whether the question was also whether I would have a mind about it, but I would think that there is also a need to come prepared, and I'm not casting aspersions, but there is need to come prepared knowing what the file says, and I'm not saying that anybody has come to court without having read the file. And so there is some value in coming having read the file. With that then, if the judges could have a conference before sitting in, at which they look at all the files that are coming up, whether it's 5.2b or the main appeals, and generally flag out what their views are, it would probably then accelerate the process of the hearing. It would sharpen their mind, the focus of their minds on what needs to be addressed in the hearing. And so the possibility of having a pre-hearing conference and post-hearing conference would in many ways probably reduce the backlog. I have many more, but can I leave it there?
Okay, in the interest of time, let's leave it there to give the others a chance. Yes. I wish you well. Thank you.
Thank you very much, and congratulations also.
Thank you, Honorable Chair, and good evening again, Council.
Good evening, Commissioner.
Now, how will you or have you addressed the issues of diversity and inclusion in your law firm, or even when you become the Court of Appeal?
In my firm, I have a diverse representation of every other person that could possibly come in, and to the extent to which my firm could accommodate. And the question of the origin, has never been a criteria in my evaluation at my firm or even in public places where I've served. The competence, the qualification has always been the criteria, and so I have never prioritized the origin. I've always prioritized what an individual brings in, regardless of the origin of the person.
Okay.
Thank you.
Now, what are the ingredients of the right to fair administrative action under Article 47 of the Constitution, and how will you apply them?
Yes. So when a decision, I'll just list them. When a decision is being made and the party will be affected adversely, the decision and the basis of the decision should be in writing. That's one. The decision should be reasonable. It should be fair. It should be effective, and should be considerate.
Now, do you think...
with a fair opportunity to be had, I think I should say that,
okay.
yes.
On resources management, do you think the relationship between the resources allocated to the judiciary and is there a relationship between the resources allocated to the judiciary and service delivery?
Whether as a third party or otherwise as an advocate, I think there has been a corresponding delivery of services as against the resources. That's the question.
So, okay, maybe I can add something. We have received a number of times stakeholders complaining on delayed judgments.
Yes.
And a lot of times people hang on, the resources are minimal.
Yes.
Is it a justification? Is there a relationship?
Yes. Okay, so let me say my view is that in the recent past, and especially after the enactment of the Constitution in 2010, the judiciary has in many ways been transparent. It has been forthcoming. It has been responsive. The expansion, the number of staff, the output, in my view, is that there has been value for money. I think that's the way I should put it. Now, the limp of the question that you've asked, secondly, is whether judicial officers should say that delay, for instance, in delivery of judgment has something to do with resources. I should say, first of all, in terms of accountability and transparency, there is the very lucky fact that there are rules now requiring a time frame within which the rulings are to be delivered, and that it's not necessarily always observed, but it's a very good measure to ensure that there is delivery. I would say if a judicial officer were not able to deliver a ruling on time, the reason should not necessarily be resources. I would attribute it either to backlog or laziness or something else, but I wouldn't see it as a resource, because by that you are already seated there, you've heard the matter, you are due to deliver the ruling, and so the resources cannot be pegged on delivery of the decision. I have seen innovations on when you are stuck with time, and I hope this will not disadvantage me in the face of the judicial officers in this panel, where because you are not able to deliver your decision in 60 days, you innovate how the 60 days is to be counted by giving a far of mentioned date, so that you start counting the 60 days when there is more latitude for you to do the writing. And I think that's still okay, because sometimes because of the backlog. And so, Commissioner, I really hope I have answered your question.
Okay. Now, finally, there has been a perception out there that JSC is protecting corrupt judges and judicial officers. if you became aware that, first of all, what is your view about this perception about, on judiciary being corrupt and JSC protecting corrupt judges?
I think it is exaggerated. I know I'm before the Chief Justice, but I would not say the judiciary is Caesar's wife. It's not 100% blame-free. But I think the extent to which it is accused of corruption is exaggerated. I also know that by the nature of judicial officers needing to be restrained, to be measured in their social interactions, it gives room and it breeds brokers who then damage the name of the judiciary. And so I would say it is sometimes the disadvantage of the environment under the judiciary works that because of third parties, the judiciary suffers a bad name. I have had to represent a judge in a situation where somebody goes to the media and starts saying, I gave a judge this amount of money and things like that. And it turns out completely that he dealt with somebody else. The person had nothing to do with the judge. They never met with the judge. The person who's being referred to has nothing to do with the judge. And by the time that is happening, it is already so extensive and pervasive in various platforms. And so I want to say that it is probably less than 20% to the battling of the allegation of corruption. And I'm leaving room for the 20% of the possibility of it existing. Then the second limb of your question was, what would I do if it came to my attention? If it came to my attention, my answer would be that the first thing I would do is that I would have the courage to mention it to the person implicated, that this has been brought to my attention, and I just want you to know. It could be my superior, for instance. And then the second thing I would do is I would indicate it to my team leader, whether it is the presiding judge or the president or whoever, that this indication has come. But I would want to be restrained and not look like the other peddlers. I would only do that if I'm persuaded that indeed it is a credible allegation. I wouldn't rush into encouraging the allegation if I have any doubt as to the accuracy of the allegation. Yes.
Thank you. Thank you.
Thank you, Honorable CJ. Good afternoon, Council.
Good afternoon.
I have a few questions for you. Please tell us, have you ever experienced opposition or rejection of your ideas from members of your team? Maybe you could give us the scenario and how you went about it, and perhaps any lessons drawn from it.
Yes, I have. I don't know whether the question extends to clients or only the people I'm working with in terms of the case, but I can answer the question in either scenario. In
course of your work?
Yes.
On a project or a task that you are carrying out?
Yes. Yes, I have. Is the invite for me to give an illustration?
Yes, please.
Yes. Okay. So I will give an indication. There was a situation where I was acting with two other advocates. We were representing a client who wanted to develop a property, and the client did not have capacity, the resource capacity to develop the property. I should say, first of all, the client is a public entity, not a government entity, but an entity with many subscribers. You could look at a mosque or a synagogue or a church. I want to avoid being specific. And so they want to develop this property. The leadership of the church then comes to me and say, we have gotten a developer, and the developer will develop the property but in exchange we will retain, and I think they were going to retain about 70%, and the benefit of 30% would go to the organization. And my instructing clients were the leadership of the body that I was dealing with. And to the extent, therefore, that my conscience wasn't comfortable with it, I did an opinion. I put my reservations in writing, addressed to both the leadership that were instructing me and to they had a number of a board of trustees, indicating to them that my view is that my conscience is that the rest of the population of the beneficiaries of the investment would be shortchanged if that were to be implemented, and I would rather it is be relooked at with a view to the institution getting more than the 30%. That is the resist. I'm just picking that to show the resistance. I unfortunately lost that client, and I lost the fees that were involved in that.
Any lessons drawn from that experience?
I don't regret doing it. I think I slept better knowing that I had taken that position. I would have rather done that than let it weigh on me.
Okay. Now, a big population of our workforce in the judiciary is the millennials and Gen Zs. I don't know whether you have any experience working with this group of people and what you'd say about them.
Of course, one of the things we could say is that they wrestled down a finance bill. Then, yes, I have them in my house. They are part of my family. The thing about it is that, unlike when we were growing up, when we were subject to directions from our superiors, it would look like the progression now is that you must negotiate with them, but simultaneously they are very agile in learning, in technology, and they sometimes surprise you by what they know. And so the issue is just to understand them and to fetch what they can, the value they can add into the situation, and to be consultative. I think that's the answer I would give.
Okay. Do you think there is anything you can learn from that group?
Yes, yes, especially on social media and technology. Every time I buy a new watch, a new phone, they would know more about it than I know, and they surprise me at how much more I didn't know about what's going on. And sometimes even in social media, I know everybody is asking what I think it's called ISO speed. Up to now I haven't understood, but they seem to understand what it is.
Okay. Now, the work of a judge is very demanding. What will you do to ensure that you balance, you have a good balance, work-life balance?
I think it's a question of time management. It is the extent to which you can balance the need to have adequate rest, recharge, and time to spend to deliver. And I think the infrastructure is in place, being the working hours, the opportunity to go on leave, the trainings that are there, the way technology can enable. All those, I think, can ameliorate the pressure that probably a judicial officer would have to shoulder in the quest to deliver.
Okay. Thank you, and I wish you the very best.
Thank you very much, Commissioner.
I only have one question outside for obvious reasons. I don't want to get into those ones. Now, I would like to know what you do in terms of social responsibility, the CSR that you do. and also whether you are mentoring other Katwas.
Thank you very much, Mheshimiwa Commissioner. I was already going to answer by saying that in terms of CSR, I am doing mentoring. So that's one. The second one is from time to time I take pop-up briefs, especially involving disadvantaged women and children on pro bono basis. And then involvement in my local environment on matters of education and generally knowledge impact, especially legal, both at my church level and my local environment. I also participate in the forums that exist in the legal circles, that is the ELC forums, the criminal law forums. That way we mentor the young advocates, and we also compare and share ideas. Thank you too.
Thank you. I think those are very many questions. But just a parting shot for you to tell us, you are a high-flying jurist. You have practiced internationally, regionally, in the country, and you have very high-flying clients as well.
Thank you for the compliment.
You know, so one is known by the company that they keep. Should you get this job, how are you going to brand yourself or insulate yourself and make the other colleagues feel comfortable that you are not part of that class or people that you represent? Because they are very high flying, they are very high level matters all over, including in the Court of Appeal.
Okay, so the main, probably I'll say the main emphasis is to say I will go out of my way to be collegial. I'll go out of my way to make sure that we are comfortable with each other, with the people I'm working with, and there is no sense in which I am perceived to have an inclination of one segment or the other. I will conduct myself impartially, independently, and in a manner that befits a judge who is not inclined or bent on association with one segment or the other. Where there are issues of conflict of interest, like every other judge, I would declare it and withdraw my participation if it is necessary.
Very well. So I think that brings us to the end of this very robust engagement with you, Mr. Katwa. On behalf of the commissioners, I wish you all the best. But before we release you, we always give a candidate an opportunity to speak to us. You can ask us a question or whatever it is. The floor is yours.
Thank you very much. Probably just two things. The first one is to say thank you very much for the honor to appear before you. I don't take it for granted. And at a personal level, it obliged me to do a lot of reading, which probably if it wasn't for what I was facing, I wouldn't go that far, and I appreciate the having been shortlisted. The second one is probably to just extend my condolences for the losses the Judicial Service Commission suffered in the last recent past. That's all I wish to say.
Thank you very much. We will get in touch with you when we complete the exercise.
Thank you very much, Commissioners.
Have a nice, I think now it's going to evening.
Yes.
It's 4 o'clock.
Yes.
Have a nice evening.
Thank you very much.
Yeah.
Am I allowed to leave with, I guess I leave the Constitution, but
Yes,
I can leave the
you can
notebook?
take your notes so
And
that nobody